We have a format here. Okay.
That is, all right.
It's fine. Hello and welcome to Philadelphia Family Pride's Paths to Parenthood series. I'm Jedzia Axelrod. I'm Assistant Director of Philadelphia Family Pride, and welcome to this session about legal concerns with our own Rebecca Nayack, who's here to offer her expertise on various legal topics concerning queer parenting. So I will give the floor to you.
Okay, thank you, yes. So Rebecca Nayack, she, her. I am an attorney at Journer Law, which is a law firm in Philadelphia. We're sort of based in Germantown, East Falls, sort of where they come together. I have been there for, 15 years. So I started there prior to marriage equality, and at the time I was doing things like getting people out of at that time, people couldn't get married, but they were financially intertangled, and so I had those type of cases where we were trying to figure that out. Some people who did get married in another state and couldn't get divorced. A lot more, contested parentage type of litigation was happening as well. And then over the years, welcome. Over the years, I saw things evolve. Where we had, slowly, at first it was the state level, then it was the federal level, and so, I saw a big evolution in that. And then, about 5-ish years ago, my law partner ran for judge, and she had been doing many of our adoption cases and our assisted reproduction cases, and when she ran for a judge and became a judge here in Philadelphia, I took that opportunity to shift over to doing that work, which I really, really love. And so that's where my whole focus has been for the past 5+. Well, I've always been focused on parentage and parental rights, but sort of doing the family building piece of that, that's where my energy has been more recently. And so before I get more into my work, I'll sort of give a little bit of who I am personally. So I'm a mom. I'm actually on the board of Philly Family Pride, and have been for a number of years, I guess. I couldn't tell you how many, but a bit. And actually, I think I owe my marriage to Philly Family Pride, because me and my wife both had children before we met each other. I had my son in a prior relationship, so he has another mom in South Philly, and we used our family building involved using anonymous donor sperm and a doctor IUI. And then we had, we separated, and then a little later I met my current wife, who was she had planned to be a single mom by choice. That was her plan. She ended up doing intentional co-parenting, and so she has twins that we co-parent with a male couple who live sort of near us. And so that's sort of our family. So we have 3 kids. My son's 10, her twins are 8. So that's our family. But in terms of what I do on a day-to-day basis, so the work that I do first of all a lot of confirmatory adoptions. I like to call them that. Technically, when you're married and you're adopting your spouse's child, technically that's the court would consider that a step-parent adoption because it follows the step-parent adoption statute. If you're unmarried, that's considered a second-parent adoption, even though sort of colloquially we use the word second-parent adoption for this type of adoption, what I like to call confirmatory adoption, because step-parent adoption seems wrong. So I do a lot of confirmatory adoptions. I'm licensed in Pennsylvania and New Jersey, so I do both states. And then I do a lot of assisted reproduction contracts. So I do egg donor contracts, known egg donor, sometimes anonymous egg donor if it's a direct donation. I do a lot of sperm donor contracts with known donors. I do sometimes intended parents agreements, if people, sometimes the fertility clinics in particular will want, if like two people are not in a relationship with each other and not intimate with each other, but are having a child together, sometimes the fertility clinics will want me to do an intended parents agreement. So they, are like, wait, what's this happening here? Is this a donor? Is this a parent? Like, let's have a agreement that says what this is. So sometimes intended parent agreements. I have done like more than two people who intended to be parents agreements. But there's some challenges with that because the law doesn't recognize 3 parents yet, but we do our best with what we have. So that type of agreement, surrogacy agreements, I do a lot of surrogacy work. And then for surrogacy, on the flip end, you need to have a confirmation of parental rights before the child's born to get a pre-birth order. So I get that pre-birth order. I also have been involved in like adoptions following traditional surrogacy. So in gestational surrogacy, it means that the person who's carrying the pregnancy, it's not also that person's egg. In traditional surrogacy, the person who's carrying the pregnancy, it's also their egg. But by our law, not every state's the same, but by our law, that proceeds as an adoption. So that's something to consider, which means that if it's proceeding as an adoption, that means one of the parents needs to provide sperm for that pregnancy. Otherwise, it would be, it would be very different. It would be a different scenario. It would be like more like just straight up adoption if there was not a genetic relationship. So I do all sorts of legal work related to family building. And so I'll sort of get into some of the like details of what those different things look like. And you just joined us, so is there any topic in particular that you're interested in sort of the legal?
Just generally the legal.
Okay, cool.
So,
Yeah.
nothing in particular.
Okay, great. So let's start with the law. That sounds like a good place to start. Okay, so currently, the law for parentage in Pennsylvania, there's no statute, which means that some states have like a statute where you can go to a place in their statute and you can look up and say, like New Jersey, for example, it says like if a person consents to the insemination of their spouse using a physician, both people are parents under New Jersey law. Like, sort of nice to be able to like look and point in like one line. In Pennsylvania, we don't currently have that. I co-chair the parentage committee of the Pennsylvania State Bar Association, and that group we've been pushing for what's called House Bill 350. It's the Uniform Parentage Act. And so that act has been enacted in a number of states. There are different versions of it. The first Uniform Parentage Act was passed in 1973, back when like there was a real problem with like children whose parents weren't married, quote unquote illegitimate children, like not getting the same rights as children who were born into marriage. And so the Uniform Parentage Act, there have been several iterations of that, but Pennsylvania has not ever passed any version of the Parentage Act or any parentage like type of act at all for children conceived by assisted reproduction. And so the most current version is the 2017 version. There was an amendment to Article 9, which has to do with like whether donor disclosure should be mandatory or not mandatory. So that was updated in 2023. And that's what we have. The 2017 version is what's pending under House Bill 350. So that's been really exciting because people have been looking at the Uniform Parentage Act as saying we should have something in Pennsylvania. I think going back to like 2008, I read a report like of a committee that was studying it, trying to get legislation, and nothing has ever moved until now. So this bill passed the House on June 24th of this year, and is currently in the Senate. It was passed by the House. The vote was 119 to, I believe, 87. 17 Republicans joined all of the Democrats in the House. So it is a bipartisan bill, sort of. And it's in the Senate. It was put into Senate Judiciary Committee. I think, we have a divided legislature in Pennsylvania. So the House, of course, is controlled by Democrats. The Republicans control the Senate. So there is a question of whether this can move in the Senate this session. I'm still, optimistic, but it definitely is an uphill battle in the Senate. We would need to have, I think, 7-ish Republicans join Democrats in supporting the bill and also have it actually get out of committee. And there are, I was told the other day, 15 legislative session days left in the year, to do that. So definitely an uphill battle. I think but we definitely have gotten a lot more momentum than we've ever had before. We've had Resolve, which is the National Infertility Group. They have written a letter of support. All major LGBTQ plus organizations, GLAAD, NCLR, Family Equality, us, Philly Family Pride, all joined a letter in support. The American Society of Reproductive Medicine, the Academy of Adoption and Assisted Reproduction Attorneys, the American Academy of Matrimonial Lawyers, I think is what they're, So a lot of people are, starting to look at this, and even, I'm hopeful it will get passed, but even if it doesn't pass this session, there's definitely an opportunity here to, look to, if it doesn't pass this session, we start again in 2025, and we'll start with a lot more momentum than we've ever had before. And what this bill would do if it became law is that it would, one, create a statute that very clearly says who is a parent and who isn't a parent. It would make that not dependent on marital status, not dependent on sexual orientation, gender identity. It would allow, instead of having to go through a whole confirmatory adoption process, which people still might want to do for certain reasons, but it would, under Pennsylvania, it would allow you to essentially just sign a form and have that notarized and have that be holding the same weight as a court order. It would give us a statute for surrogacy. And so it would create a de facto parent status, which means if you've lived with a child earlier in their life and have become their parent, basically, even if you don't have a genetic relationship, that you could be considered their parent. And so there's a lot, it would do tremendous things to our law. And so that's pending. We're working on it. We're actively working on it. So it's something to keep your eye on. It's something to call your senators about, state senators. But it's a project. So what do we have right now? Absent that amazing law that I hope passed. What we have right now is case law. So we have cases that have come before that have set precedent for who is and who isn't a parent of a child conceived via assisted reproduction. And what that case law says, when you put it all together, you sort of have to read this line of cases that all sort of cobble together. And actually I'll tell you about, since we have time, I'll tell you about some of the cases. So one of the cases that I really love is called Ferguson versus McKiernan. That case had to do with a known sperm donor who donated sperm to a single mom by choice, who he happened to be her ex-boyfriend, but at the time of the donation, he was clearly a sperm donor. They did it with a physician, and she had twins, and then 5 years later, she sought child support. And so that case made its way up to the Pennsylvania Supreme Court, and they said, no, he's a donor, not a parent, there are no support obligations. So that was and what they looked at is, even in that particular case, there was not a written contract, which of course there should always be a written contract to, keep there for being sort of competing stories. But in that particular case, it was an oral contract that the court found, and they said that, that he was a donor at the time, they used a doctor, they structured their lives, with the intention that he was a donor, and so they found a contract. Then another case that I really like to talk about is called Baby S. It was a case that my firm actually handled for the intended father about, I think it was 2017. And what that case was about was, it was a surrogacy. So it was intended mom, intended dad, married to each other, who contracted with a surrogate gestational carrier to carry a pregnancy, and they used not the intended mother's egg, but donor egg. And so mid-pregnancy, they broke up, and the mom, who actually was Sherry Shepherd from The View, who I didn't know who she was until this case, but she was on The View. So so she didn't want to be a parent to this child that she had, signed a contract with the, egg donor, signed a contract with the surrogacy agency, signed a contract with the gestational carrier, and she decided that she didn't want to be a parent. So she challenged all of those contracts. And what happened was the court said, no, but for your actions, there would not be a child here. So we are enforcing the contract, and you are a parent. And so she took that up to the Superior Court, which is our middle court, and the Superior Court said, no, agreed. They said she's a parent. And again, it was all by principles of contract. Then, and the Pennsylvania Supreme Court did not take that case, so the Superior Court had the final say on that one. Then there was another case that I'll tell you about. The outcome was not good, but the sort of the reasoning in the opinion was good, even though it didn't work with the facts. And my firm represented the non-biological parent we didn't do the trial work, we didn't do the Superior Court work, we came in at the Pennsylvania Supreme Court level. But that case it was sad, it was not the best facts, but it was a couple who lived in Florida at the time. They were in a relationship, they were not married because they couldn't be married, and they had a child using anonymous donor sperm, and then they separated. The really bad fact that is sort of why this case ended up not working out well in the facts was that the biological parent who carried the pregnancy moved to Pennsylvania, and the other person, I forget when she moved or didn't move, but she didn't do anything for 2 years. And so that was the really bad fact. But from our perspective, they were both parents. And so we made the arguments relying on these principles of contract. And the court in that opinion said, yes, because there was a really the Superior Court said you can only be a parent by biology or adoption. And we were like, wait, we can't let that stand. We can't let you say you can only be a parent by biology or adoption, because we know we already have these other cases that say you can be a parent by contract. And so we're like, so that doesn't work. We can't let that stand. We have to have the Pennsylvania Supreme Court correct this. And so they did correct the law. They said, you can be a parent by biology, you can be a parent by adoption, you can be a parent by, contracting to be a parent for a child born by assisted reproduction. But they said, it doesn't work on these facts. And so while we sort of got the law corrected, the facts, the outcome was not good for the client, but at least we got the law corrected. So they sort of suggested okay, when the next case comes along, maybe we're open to, there was a really good concurrence. So there's the main decision, there's a concurrence from Justice Wecht, who I love. And he, sort of said I would go a step further, maybe parentage by contract. Which brings us to the current Pennsylvania Supreme Court case that is pending, which in that case, it was a same-sex female couple. The person carrying the pregnancy, it was also her egg, and they were married, and they separated prior to the child being born. And so the person who was genetically related and carrying the pregnancy, didn't want her wife to be a parent. And so the case came out of Philly. So there was a trial in Philly, and Judge Solomon said, he read all the case law. He said, principles of contract, you're both parents. And non-biological parents' name should go on the birth certificate and that. So that went, that was the decision. It went up to the Superior Court. The Superior Court put out originally, so when it goes to the Superior Court, a 3-judge panel decides. Originally, they put out a bad decision, and they said, like, we don't see a contract, like, where's the contract, like, and they were pointing to, like, well, we signed this with the cryobank, we signed this with the doctor's office, we initiated the confirmatory adoption, and the first decision of the Superior Court was like, there's no contract, these things aren't contracts, they're more like consents. And they were also like, and why are you doing the adoption if you think you're a parent? So, which is why I like to call it confirmatory and make that clear. So then the attorney representing the non-biological parent asked for the Superior Court to review that decision. So when you review that decision, you get a 9-judge panel, and the 9-judge panel basically said, forget what that 3-judge panel said. Here is our new decision, and they said that they were both parents, and they also they said they suggested that in addition to principles of contract, there was parentage by intent, which was like pretty cool. And I think that is why. So now it's before the Pennsylvania Supreme Court. And I think that's why the Pennsylvania Supreme Court took it, is to see like if they'll establish this parentage by intent concept through our case law. And so that's pretty exciting. Like, it would be pretty cool to get that. So we have like a couple like hopeful things that are advancing our parentage law. Like we have the bill that's pending. We have this case that's going to be heard. It's going to actually be heard here in Philly on September 11th in City Hall, like the Supreme Court courtroom, which I think is just open. I'm planning to go and watch. And Philly Family Pride actually was part of wrote a friend of the court brief in support of it. So there was the main brief, and then there were actually like a number of friend of the court briefs. There was one that Philly Family Pride participated in, along with some other LGBT advocacy organizations. There was one that the Philadelphia Bar Association wrote along with the Allegheny County Bar Association, and I believe the family law section of the state bar. So there was an attorney brief that was written from a number of bar associations, and then there might have been one more friend of the court brief. So that's exciting. That's pending. We'll see probably late fall, ish, hopefully, what the Supreme Court of Pennsylvania is going to decide on that issue. But what I always, and I should talk about the marital presumption, because that's really important as well. So the marital presumption is the idea that a child born into a marriage is the child of both spouses. And that concept comes from prior to DNA testing, prior to same-sex marriage, there was this concept, and it sort of was the idea behind it, as expressed in Pennsylvania case law, is that it's to prevent marriages from being attacked from the outside. And so there was a case, I think it was a Philly case, but it was in dependency court, and it was about whether it was a married couple with a so it was a married couple. The non-biological parent was a trans man, and the court was deciding whether or not he could participate in the proceedings as a parent. And the whole case turned on, it seemed like there was a rocky relationship, and the whole case was about whether or not their marriage was intact so that he could participate in the proceedings. So at the end of the day, for that particular case, the court found that the marriage was intact and he could participate. But when you read the case, it makes it very clear that if you don't have an intact marriage, you don't have the marital presumption. And so I don't have confidence that certainly in the event of a separation, the marital presumption wouldn't be applied. And then also, if someone passed away, I don't think you get the benefit of the marital presumption in that scenario either. And so I don't think the marital presumption, yes, it gets two people on the birth certificate because that's the way that birth certificates are issued for married people, whether that's like, that's the default, whether it's true or not for like, it's the, whether it's the intention even or not, that's the default. So it does get you on the birth certificate, but like for example, in that case I was talking about that's pending in front of the Pennsylvania Supreme Court, they didn't rely on the marital presumption at all because there was none. There was not an intact marriage. And so none of the decision in it, or really even the argument, was focused on the existence of this marriage because the marriage wasn't intact, so it was not a winning argument. So that's where the marital presumption is. So let's see. So I think, so that's all Pennsylvania law. And so the reason, I actually think that Pennsylvania law is not bad. Like if I have a client sitting next to me and they're being told they're not a parent, and I can point to all these cases and say like, yes, they are a parent. But one, no one should ever have to do that. Like that is a terrible scenario. I have sat next to those clients and I have one for them, but it comes with sometimes not seeing your kid for 4 months, or being like, put in a position like, well, maybe if I just asked for less time, maybe they, the other person would agree to this. It's like not a good, situation. Of course there's, you mentioned like the fear of people that if someone like passed away, if there are any hostile family members, that's a concern. There's a concern, case law is case law. Like we saw what happened with Roe and Dobbs. So even things that like we thought were like, solid, like cannot be as solid as we think they are. And so those are some of the reasons why people do confirmatory adoptions. Another big reason is that everything I just told you only applies to Pennsylvania. And so every state has their own nuances in deciding who is and who isn't a parent, and the law varies. But there's a United States Supreme Court decision that says that and also the full faith and credit clause that says that adoption decrees need to be recognized by every other state. And that's not true of birth certificates. Birth certificates are really just like a record of what's reported at birth. They can be amended and they don't need to be respected by other states. And so sort of the portability issue is also another reason why people do confirmatory adoptions. So that's sort of like, I guess, a legal landscape overview before I get into like some of the nuts and bolts of these different ways of family building. Are there any questions about the law? Yeah.
You use the word or the phrase intact marriage.
Yeah.
I assume this is prior to divorce. But
It's prior to divorce,
what
and it's
defines
like,
intact
I
marriage?
actually, it's interesting because I've had to me, a marriage is if someone's saying the marriage isn't, if someone who is in the marriage is saying the marriage is not intact, then maybe you don't have an intact marriage. But to me, I've had people who are separating, and they're like, how do I get this person, and they were using a sperm donor, and they're like, how do I make sure that that person I'm separating from is not going to be considered a parent? And for me, the line in the sand is that I don't really feel comfortable drafting a known, say it was a known donor, or say it was just someone asking me that question, they're separating, but they're on their fertility journey and they're ready to move forward with the transfer, and they don't want their spouse who they're separating from to be a parent. For me, the line, I would feel comfortable with a divorce complaint filed and separate households. But certainly better, all the way divorced, not married. Because I think that could lead to problems at the time of the birth. And also, if they were still married at the time of the birth, the spouse is a presumptive parent, and so that's or at least it would be a problem in some ways, certainly within the adoption context, because you need to give a presumptive parent notice of an adoption. And also fertility clinics, that's sort of what I think, but I know some fertility clinics will not allow a person to use donor sperm if they're married to someone who's not going to be apparent at the time of the insemination procedure. And I think different clinics have different policies on that. Any other questions?
Well, the case law, is there a certain resource online to keep track of it and get updates? Like,
Well,
that you're
the
aware of?
case that's pending in the Pennsylvania Supreme Court currently is called Glover versus Junior. And so I think if you just
Sure.
search that case or put it in, that's a pretty important case. There was an Inquirer article about it. So and if you're coming from this from a legal perspective like I am, if you look in that case, it cites all the other cases I mentioned. And then just be looking in the fall, late fall is when I think we'll see that come out. And I think it'll get it's a Pennsylvania Supreme Court case, so I think it'll get a little attention. Any other questions? Okay, I'm gonna move it to nuts and bolts then. So let me do nuts and bolts of contracts, donor agreement, egg donor agreement, sperm donor agreement, gestational carrier, because they all sort of in some ways flow in the same way, and some of them cover the same issues. Oh, embryo donor, I forgot to mention embryo donor contracts as well. So all these contracts, usually the way we're basing them on that law. The Pennsylvania really cares about contracts, and so I cite that law that I told you all about this is an enforceable contract. The other things that those contracts cover when we're using gametes is that one, we would make sure that if it's a sperm sperm donation can happen, so we'll start with sperm donor. Sperm donation can happen at home or with a fertility clinic, are usually the main two ways that I see. And so, fertility clinics are going to, anytime a fertility clinic is involved, they're going to have their own requirements for FDA testing, for any quarantine periods that are their protocol. They're going to have, as part of their process, folks meet with a psychologist, which I have mixed feelings on, because it's really a psychoeducational consult. And so I think that meeting, even for people who are planning on doing at-home insemination, I know that there are all these sort of barriers, and that can feel like another barrier, or why do we have to do this when no one else has to do this? But I think that good information can come from that. Because I know that there are issues that I didn't think about when I was having a child. I was have a child, which donor profile do I like? Which what is their health history? What is their do I let me look at their childhood lifetime pictures? How does that fit in? What is their ancestry? Does that match? My partners, that sort of thing. And you're focused on, or I was, having a child. And you don't, or I didn't, think as much about as I wish I had about, donor siblings. How many donor siblings could there be? Where could they be? I picked ID options. I think now for most of the major cryobanks, all the donors are ID options, because there's really no such thing as there's no one's anonymity is forever. That there's DNA testing, there's 23andMe, Ancestry. If someone wants to find someone through DNA, it's not that hard anymore to do that. You'll find a cousin and you'll be able to sort of figure things out. So there is no anonymity, and I think that sort of the psychoeducational consults that the clinics make people do, really, and I don't think they don't do that, well, they don't all do that for anonymous sperm donations. For known sperm donors, I believe that it's a requirement, but I think it has everybody have some, conversations and really have to look. With a known donor, it's well, what is this person's involvement in the life, a child's life going to be? And I've had a number of people have to have, very clear conversations that legally you can be a donor or you can be a parent, that there's no middle legally. But that's not how like people's lives always work. Like I know that for some people they sort of like conceive of like, well, this person, like we're gonna, they're gonna, contribute sperm to this pregnancy, and maybe they're going to like see the kid every, couple of weeks, on a regular basis, or maybe they like have offered to help with like some childcare expenses, and there's these sort of like scenarios where people are conceptualizing it working one way in real life, and maybe it will work that way, but like the law, like you need to be clear, like, is this a donor or is this a parent? Like if it's a co-parenting situation, like great, we'll go with that and we'll do a co-parenting agreement. If it's a donor situation, we'll do a donor agreement. But legally, it's like you get all the rights and benefits of parenthood, or you get and all the obligations, or you get none of them. And what happens in real life, like a donor could sure make like gifts of money to a child, but that's not going to be enforceable like child support. And so it's really important, like for some of these relationships that maybe are somewhere more in the middle, like legally you need to be on one side or the other. And I think that like the psychoeducational consults, they can help sort of talk through all different issues of confidentiality, like who can tell your child, what will donor sibling relationships look like, what they'll be able to talk about those things. So the contracts itself, going back to that, like of course make clear that a donor is a donor, not a legal parent. Go through that if there's medical intervention, that they're going to cooperate with that. If there's not medical intervention, there's probably still going to at least be like some STD testing that they should cooperate with. It'll go through like what expenses are going to be paid. Like if a donor is traveling from California or from the United Kingdom or wherever, like what costs will be covered for the donor. To me, it's important that the donor always know that they can have legal counsel as well, and that is paid for by the intended parents typically. So that's sort of like the expectation. If the donor's like, oh no, I want to pay my own way, then that's fine. There's not a prohibition on that, but generally intended parents pay for donors' attorney fees. There's not a legal requirement that there be 2 attorneys for a donor contract, but it's the ethical guidelines from the Academy of Adoption and Assisted Reproduction Attorneys, which is sort of like our main professional organization for people who do this, that says there should be. And it does provide extra protection because it certainly prevents a donor from ever saying like, I didn't know what I was signing, or I didn't understand that I was signing, or I thought it could have, like it shuts that down. And I have gotten those phone calls too from like a donor, like a donor who signed something and then it's like, wait, I want to be, what? No, I didn't agree to that. And then, and that could be like right now, like immediately while first pregnancy is going on, or it could be like, maybe there's one child and then like the donor's been involved and then there's a second child and the donor's like, well, I want to make sure that for sure I'm involved, and they need their cooperation with the confirmatory adoption is much better than if they're not cooperating. I think there's a way around it, but if they're gonna just like sign, there's a consent as part of the adoption, like where they're saying like, and I always title it like consent of like known donor, genetic, whether it's genetic parent, that they're gonna sign at the time of the adoption, which is which that can be signed before a child's born, but it can't be filed with the court until after a child's born. And so they're gonna sign that. There's a way to do an involuntary termination, or possibly even just like include the contract and not do it at all. But I prefer to do it because then you have the court order saying that this person isn't a parent, and it's just like very clear. Like you have a court order that says this person's not a parent. No one can ever say they're a parent. There's a court order that says they're not. Even though there's also a contract that says they're not. It's just nice to have that judicial confirmation because again, it needs to be recognized like everywhere. So attorneys on both sides that paid for by intended parents. It'll talk about like confidentiality. Generally, like who can you tell? Who can you? It doesn't necessarily have to say who you're going to tell, but it should say like we'll agree that if we're going to tell other people, like we'll tell each other first before other. Usually has like a social media, like don't post on Facebook without permission about the donor arrangement. And generally, like the psychologists also say that telling a child their conception story as early and often as possible before they really understand it is best practice. But at the end of the day, most intended parents want to have control of how they tell their child and when. And so that's, confidentiality, social media, that's something we cover in these agreements as well. If there's going to be stored genetic material, we cover what can be done with it also. What can be done with any stored sperm, what can be done with any stored eggs, what can be done with any stored embryos. Can they be donated on? Can they not be donated on? Do they have to be donated on? All sorts of, that's all contemplated in the agreement. And so that's some of the main topics that sperm donor agreements cover. Egg donor agreements cover pretty similar things. Of course, for egg donors, there's always going to be medical intervention. For sure you're doing some of that. You can compensate for both sperm donation, egg donation. There can be some compensation. Usually it's for like the, not like here, I'll give you $10 for your egg, but it's more for the process of doing it. And it's not $10 for eggs. It's like people are charging I've seen very high amounts. But it can also be altruistic. There doesn't have to be compensation in the agreements. But largely, many of the topics for egg donor agreements and sperm donor agreements are pretty similar. And same with embryo donation. Embryo donation is interesting because a lot of times people create embryos and they're not creating them at the time with the idea that they're going to donate them. They're planning to use it for their own fertility, and then they have extra, and they're and so those are largely covered. Some topics that are similar, like confidentiality. There's not compensation for embryos. That's not something that we do. There can be covering of expenses for attorney fees or storage fees, but there's not compensation for embryos themselves. And of course, we've seen all sorts of things with embryos in the news. But luckily, in Pennsylvania, embryos, are not considered in Alabama. I don't know. In my world, I saw that decision very clear. Alabama embryos could be considered people or are considered people, and there's a lot of big implications of that. But that's not what we have here. Embryos, are property of a special nature, and that's what we have here. So that's some of the components that are included in various types of donor agreements. Before I get off the topics of donor agreements, is there anything that I didn't touch on or that people have questions about? Okay, no? Yeah, okay. So let's do, I guess with the donor agreements, I think that sort of goes nicely into the confirmatory adoption. So I'll come back to surrogacy later. I'm gonna write myself a note. Come back to surrogacy. Okay, so for the confirmatory adoptions, so like I explained before, they proceed, if people are married, they proceed as quote unquote step parent adoptions. To the court, that's how they're looking at them. Or maybe that's the statute that they're following. I think many judges get what we're doing and that we're doing it for the extra security, and some judges are even, why are you doing this? You're both on the birth certificate, so there's some education that goes on some places. But what is generally filed with an anonymous donor for a confirmatory adoption, when I should speak about marriage. So marriage, there was a case back last July that the name of the case is MEL, not Mel, but it's like anyway. And it had to do with, it was an opposite sex unmarried couple who, with a child who had been born of a prior relationship, and they were unmarried, and so the one partner was trying to adopt the, in that case, woman's child, and they had grounds to terminate the rights of the biological father, and so the court found that there were grounds, but they found that they could not complete the adoption because they were not married. And the reason is, it's very weird in our case law, because you can actually, an unmarried couple can adopt a child that's not related to either one of them. So but you can't adopt your partner's child according to this case unless you're married, because there's this relinquishment requirement, like that the biological parent has to relinquish, and there's an exception to that for a spouse, but that's how the statute reads, and it says you have to show good cause. And what this MEL case said was basically it said it raised the bar on good clause, and in the way they read that case, it made it seem like you had to really almost have legal impossibility. And so for 20 years, we've been doing second parent adoptions for same-sex couples, prior to marriage equality. And then it's you read this case, and now courts can sort of say, well, now you can get married, so you have to get married. And when this case came down, now not every county is doing that. So when this case came down, I think I was handling adoptions for maybe 4 or 5 couples who were not married to each other. And a lot, and there are reasons, I'm sure you guys know, people may not get married because student loans was a big one. I think that was, of the people who it was a small sampling, but that was a reason for a few of them. Some were just well, we don't really want to get married unless we have to get married. And so that was another reason. And I wasn't sure, what the court was going to do with this case, because obviously it was different circumstance. In that case, you were terminating someone's rights. It wasn't the assisted reproduction case. And so in Philly, I wrote a memo, and Philly, they're going through just fine. That's the only county where I've had to use that memo so far. I haven't really had an occasion to try it in other counties since last July. So I'll see if it works in other counties. I know that Lehigh County is pretty strict on it. I would tell people in Lehigh County that they will probably not get an adoption decree unless they're married to the birthing parent. I think York probably falls into that. But we'll see. I mean, right now, that's, I tell folks, if you're not married and you're adopting your partner's, child, I can't guarantee you an outcome in a county that I haven't tried it in yet. But there is another option. So when that case first came out, I was I don't know if any court, even Philly's gonna do this. And so I had a couple who had retained me early enough that I tried filing it as a pre-birth order. So I asked the court to enter an order declaring that they were both parents prior to the birth, and I got some instruction from Vital Records as to how they would register that if I got the order. And so they said that yes, they could register it if they'd honor the order. And so I got an order. In that case, it was reciprocal IVF, and I got that order from Philly. It was very easy. It was on the papers, and it was, and then it worked, and I got both people on the birth certificate. And then I had the same thing come up in Bucks County. It was people, contacted me early in the pregnancy, and they were unmarried, and they were willing to try getting a pre-birth order. And so in Bucks County, it required a little bit more work. We had a hearing. I wrote a memo, but I did get the order, and that child was born I don't know, a week or two, or maybe the child was born. I just saw pictures yesterday, so that was pretty exciting. So there are some workarounds. People are I really don't want to get married, but it's very, I think at this point, very dependent on counties, how they're looking at the marriage issue for second parent adoptions and whether it's still possible in these circumstances. So in terms of process, so when we file a confirmatory adoption, they'll, in all the counties in Pennsylvania, you file a petition. It includes demographic information for both intended parents and the child. it has attached to it, assuming they're married, a marriage certificate, child's birth certificate. It has clearances. We have to submit clearances for any state that folks have lived in for the past 5 years. So those clearances get attached. And then we also include, if it's an anonymous donor, what I do is I include an affidavit from the cryobank and an affidavit from the doctor. If there is no doctor, an affidavit from the parents regarding the circumstances of the insemination or IVF or whatever it was. If it's a known donor, if there was a doctor involved, I'll include that, or a midwife involved, I'll include that affidavit also. And then I do that petition where formally I have them sign a consent to the adoption, and then I formally I file to confirm that consent with the court. And so that's how I do that. With reciprocal IVF, so one partner carrying the other partner's egg, I do it as like, in all of these, I call it, my view is that everyone got parent already, we're just confirming it. And so I, in co-IVF, I do gestational parent, genetic parent, and say we're confirming rights for both people just to make sure everything is as secure as possible, and I don't say that one person has greater rights than the other. In some states that have a statute, the birthing person is the person who's a parent at the beginning, but we don't have a statute, so in Pennsylvania, the person who gives birth, if people were unmarried, that's who would go on the birth certificate, but that could be challenged by genetics, and so I just, think it's unclear currently in Pennsylvania who, if anyone has greater rights, who does, and so I just, say, genetic parent, gestational parent, confirming rights for both. So that is what the process looks like in terms of filing. There's always a short court hearing at the end. In a few counties in Philly, there is an interview with a social worker prior. It's not like a whole home study or anything. He's a really nice guy and he gets what we're doing. I know Allegheny County, Pittsburgh, they have someone come out to people's houses, because the court, even though there's not a home study required for this, the court can do its own quote-unquote investigation. Usually that's pretty innocuous, like this interview, and I understand that what Allegheny County does, even though they come to people's houses to do it, is pretty similar. I know the main counties around Philly, like Bucks, Delaware, Chester, they don't have that type of interview, but if it's a county I haven't been in, maybe they all have their own little nuances. So that's what the confirmatory adoption process sort of looks like. Those hearings are really simple. They're almost like a checking of the boxes, unless should this adoption happen or not, that's not usually, that's not how they are. They're very much you confirm the information that's in your paperwork. Do I have the required clearances? Okay. So that's confirmatory adoption. Before I move on, I guess I'll talk about surrogacy. Before I move on, any questions on confirmatory?
Did you say earlier that process for the confirmatory adoption can get started before birth of the child, and then you file after?
Yeah,
birth?
so I think it's good to start before, because when you have a newborn, you're the first thing on your list is not to go get your fingerprints done. And so I sort of encourage people, I think end of second, beginning of third trimester is a good time to get started. The clearances are only good for 1 year, and usually the hearing, even if I file pretty close to when the child's born, the court's probably still going to take 2 months to schedule it. So you don't want to file prepare find out oh, I'm pregnant, let me run out and do all my clearances, because then they could expire. But I think end of second trimester is a good time to start on that process.
And then I know you said that for reciprocal IVF, you would file both as both parents.
Yeah.
Is that two different
Oh no, it's one
It's
thing.
one hearing.
Yeah, it's one. It's one petition even. It's
Oh, gotcha.
co-petitioners in one petition, and there's an option to do it as for all of these, as co-petitioners or the person who's adopting petitioning. I always, except for in Chester County for whatever reason, I always do it. But my tendency is just to do it as a co-petition. Any other questions? Okay, so let's do surrogacy. Okay, So surrogacy, there is traditional surrogacy, or now, if we got the Uniform Parenthood Act, it would actually be called genetic surrogacy, and it would be legal, and it would proceed in a more way that's aligned with surrogacy. But traditional surrogacy is the person carrying pregnancy, their egg. Really, I don't think that there's a contract that you can do that's enforceable prior to the child being born. Certainly people can write down their intentions in a memorandum or something, but I don't think if a person, under our current law, a person who's giving birth can't really sign away parental rights before a child is born. So that, but I have had adoptions following traditional surrogacy, and so what those look like are pretty similar to confirmatory adoptions with a known donor. Is the surrogate is signing a consent to an adoption. They cannot sign, the donors, sperm donors can sign that consent prior to a child being born. The person giving birth can't sign a consent until 72 hours after a child's born. But so they'll sign that consent, and then there's certain other notices that we need to give as well. They'll sign everything we need to consent to the adoption, and then we file the petition to confirm their consent and the adoption, and that's what we do for traditional surrogacy. So it's very similar. With gestational surrogacy, so it's not the surrogate's egg, there's a contract in place before. These are super long contracts. They're I don't know. The shortest one I've seen is maybe 30 pages. They're 30 to 60 page contracts. And they go through everything, what are people's intentions with regard to parentage, what dietary restrictions are there, during the, it goes through everything. It goes through compensation, and yes, there is altruistic gestational carriers, but if you're, but there's a very, there's a whole industry to this. And so when I see compensated gestational carriers for their base compensation alone, I would say these days it's unusual to see. If I saw $35,000, that would be on the very low end, and that's just their base compensation. The other things that are usually covered are any expenses or lost wages or extra fees for embryo transfers and extra fees for C-section invasive procedures, things like that. So, and then of course there's the whole medical side to it as well. And then there's also, if people are finding each other through an agency, then there are agency fees, and and there's a whole range of what agencies offer. Some have these all-in packages, where they're you pay us this one big fee and we'll cover all these different contingencies. And some are, the contingencies are more with some I think Circle, it's sort of more all in, and hey, if your surrogate goes on bed rest, your fee is still the same, things like that. But others is you only pay bed rest if your surrogate's on bed rest, things like that. So it goes through a lot of compensation, medical restrictions, making sure people are aligned on what would happen if there needed to be selective reduction or abortion, for either, making sure people have the same views. So it's all outlined in this really comprehensive document. And then prior to the birth, we start on a pre-birth order. And so for that, there'll be consents that the gestational carrier signs. There'll be affidavit from the doctor. If there's any donor gametes being used, we'll have affidavits showing that if they came from an egg bank, we'll have an affidavit from there. And so we put that all together. We file it with the court prior to birth, and then that results in, we send it to vital records in the hospital, and that results in both intended parents being on the original birth certificate. So that is sort of a quick surrogacy overview. Is there any questions on surrogacy?
That was really helpful.
Cool. Yeah, and I've seen people have their sister or a really good friend. It doesn't, it could just theoretically be the medical expenses and the legal expenses and the psychological clearance expenses, and that with I have seen that not just a handful of times, more. I see that, but there has to be that person.
Mm-hmm.
Yeah. Anything else?
Broadly, questions. I was wondering if a parent goes through a legal name change after the child has been born, what are options with like Pennsylvania birth certificates and
Oh
stuff?
gosh, so Ben did all the, like, so I can,
Okay,
if I do the adoption, I include the name change decree because I have to in the adoption filing. Afterwards, oh yeah, no, I do know this. There's a way where there's like some forms that you can send in to get that record updated and you have to show the court order. I do know that.
Okay.
Yeah.
Because I know state by state for getting like my own birth certificate changed is like a whole thing state by state. So I was wondering
Yeah.
about being a parent on the birth certificate in
Yeah.
Pennsylvania. Great.
Oh,
thank
and
you.
also I should mention, like, for unmarried folks who have a child, after the adoption, the birth certificate is updated to reflect the names of both parents. So if they're unmarried and they file in a county that will allow for a second parent adoption, then after the adoption, their name goes on the birth certificate.
I was also curious if you could tell us like, okay, it's like the end of the second trimester. I called Journal Law Group. Like, what does that process look like to engage a lawyer for this? Is it like 3 meetings usually, or like
So usually it's like a phone call first, like people, so if I get a call or an email or my, assistants get a call, like whoever, the call comes in, or email comes in, I'll schedule a consult. We don't charge for those consults. And so I'll, give, some version of what I told you all tonight, more focused on, the particular circumstances. So give an overview of the law and the process. And then following that, we send a representation agreement. And then, once that comes back to us, then we send instructions of, reminding all the clearances that you need to do and how to get them done. If there's a form, if people have lived in another state, directing them to the appropriate form or including it. If people live in Pennsylvania, we've got that down. It's easy. Sometimes we have to like track down, child abuse clearances from other states and what they look like. And so we, send that. It'll have HIPAA forms attached. So if there's a doctor or a cryobank involved, we'll get affidavits from them, and then get started on the paperwork. That's for adoption. For like contracts, same sort of thing. Like I'll have an initial call. I'll talk to people, explain the process, have an intake form, do a first draft of a agreement. There might be questions that I had that weren't answered on the intake form, or I didn't ask on the intake form, or people, once they see what the contract looks like, like they have that document and they'd be like, well, this line, could we say this like a different way? Or do we have to say this? And so like we'll go through the document. I'll make sure everyone, understands what all the provisions, that they're clear, which I think it's pretty clear. Like most people aren't like, oh, this is legal jargon, I don't understand. Like most of the time, those aren't the questions that I'm getting. Like I try to write it in a very clear way. But certainly like making sure that it is clear and then, tailored to the particular situation. So that's what it looks like then. Once I, draft it and it's approved, then it will go to whoever it's going to, whether it's sperm donor, egg donor, embryo donors, gestational, carrier, attorney, or, in the reverse, if I'm representing the donor, usually someone's, or gestational carrier, usually someone's sending me over a contract, and if my client's the, donor, gestational carrier, then I'm reviewing it and I'm saying, well, maybe we could say this, or let's change this, or I like, so we'll go through like any tweaks we want to make or changes and send those back. So there's a little like back and forth, but usually that, it's not like, we're not at the negotiating table. Like people are building families, like these are not contentious negotiations by any means. I would say like, the most like longest negotiations happen for, sometimes in the gestational carrier sphere, just because there's more, there's a lot of things to think about, like what happens if someone does go on bed rest? How is the pregnancy going to be covered? What insurance is going to be used? Has the insurance policy been reviewed? Oh, it has an exclusion. What are our options? Like, there's a lot that goes into that. So sometimes, figuring out that, but, generally, these negotiations are not like tough negotiations. They're like everyone has the same goal, and so we're making sure it's clear, everyone's like aligned, and that everything's tailored to how they want it to be.
Okay, and then once everybody, yeah, I guess all those contracts just have to be signed between the people. We don't have to like go talk to a judge about it.
No, yeah, they're just
So
like
then-
they're just kept like they're held privately. So they're signed. I ask people to get them notarized. That's again not a legal requirement, but I think it's better if you sign in front of a notary because no one could say, oh, I only had page 10. Like so it's good to have that notarized, and then and then people just send it to me if folks are working with a fertility clinic. The clinic's gonna want a legal clearance letter, so I'll provide that. And if they're not, then they store it, I store it, and hopefully you never need it. But if you do, it's there to rely on. Well, and it's also there like for some like confidentiality provisions, things like that to look back on.
Cool. And with confirmatory adoption stuff, is that you have to talk to a judge for that one?
That one you do have to go to court in Pennsylvania. In New Jersey, you don't. In New Jersey, it's like for folks in New Jersey, it's a more streamlined process because it's just a more streamlined process. But I don't
Sure.
think, at least here, maybe on the camera, someone's in New Jersey. But I think, are you all in Pennsylvania?
Yeah.
Okay.
Yeah.
Yeah.
Okay, so that's probably similar.
Yeah, I won't
to
make
what-
you jealous of New Jersey.
Should
Save it for another
I move across the river? Okay, that's helpful. I'm just like visualizing what does this look like, and like I've personally been through a legal name change process, so I'm like, I met with the attorney, I filled out the paperwork, and then I went and sat in front of a judge, and the judge ticked the boxes, and I moved on with my life.
Yeah, and that's
Sounds similar.
sort of what it's like. It's like a lot of times people are, for adoptions, like they talk to me at the beginning. We all work on getting paperwork. There's like emails like, hey, is this the right clearance or whatever, and then people send me their paperwork. I prepare all the documents, send it, mail it so they can sign it, review it, make sure everything's correct. Gets filed with the court. Prior to the court hearing, I'll have a phone call with them, and then we see each other in person in court. Usually, like these days, like people are welcome to come to my office, but people are doing things over Zoom. Like it's very, very rare that I have a client come in person to my office, unless they want to. They're welcome to, but usually it's like phone, Zoom, and then for adoptions, those hearings are in person.
That's so cool. Thank you.
And the baby has to come. I don't know if I said that. Baby or
Cool.
child or has to come.
Great. And do you feel comfortable sharing like range of possible costs? For
Yeah. So for sperm donor agreements that are currently like a flat fee of, so the agreements we do, well, most everything we do on a flat fee for this type of work. So those at my office are currently $1,100 for sperm donor agreement. Egg donor agreement is slightly more, as is embryo, but still like under $1,500. What else? Adoptions. Without a known donor, the base fee is $2,400 currently, and $2,700 with a known donor. Then they're on top of, there's some variation, so that's the base fee. If someone like told me they lived in 5 states over the past 5 years and it requires extra clearances, it might be a little bit more, but we're talking about like $100 or $200 more, not like, that's sort of the range. And then plus whatever court fees there are. Philly is the most expensive county to file in, but I believe in Philly we ask people to put $550 into cost to cover things like the filing fee, clearances that we can run, requesting any like original copy of marriage certificate or other things, and then we just use what we need and send back what's remaining. And in the other counties, I can ask for a little less. Usually it's about like under $400 for costs, in like because the filing fees are a little lower.
And the gestational carrier agreement, do you know the fee on
That is just under $3,000 for the agreement. The pre-birth order is just under $3,000. Like unless people here there are sometimes it's always under $3,000. Like sometimes there's a post-birth order for international people, but that doesn't apply to this group. And so there's some other considerations, but usually right under $3,000, and plus court costs.
That's really helpful. I appreciate it.
And there's always has to be a reviewing attorney, so that's just for the drafting attorney.
Okay.
For the reviewing attorney, they're going to charge whatever they charge. It's another attorney's office, so they're going to have their own fees. But for like reviewing gestational carrier agreements, the going rate is somewhere between 1,500 and 2,000. For reviewing donor agreements, I would say the going rate is between maybe like 650 and 1,000.
Is that the only time you need a reviewing attorney? Is for those two cases then?
For the agreements, for the like pre-birth order for gestational carrier in Philly, or not in Philly, in Pennsylvania, you can do it with one attorney, but sometimes there is a second attorney. But their, fees, like usually they're just there to like, make sure that the gestational carrier feels comfortable signing the paperwork. And so the fees are pretty like low. There's not a court hearing for, except most counties don't have a court hearing for a pre-birth order for a gestational carrier. Usually it's just on the papers. Montgomery County has a virtual hearing. I think Northampton has an in-person hearing where like the attorneys have to show up, but the clients can appear on the phone or something, Zoom. So like there are a few places where you'd have to go to court for that, but most places you just send the paperwork to the court and they send back an order.
And then I also wanted to ask, since things are so state by state, if my family were to move to another state, should we consult an attorney in that state to make sure our shit's gonna hold up?
Yes, so the adoption decree, like if you get an adoption in Pennsylvania, because we have a United States Supreme Court case that says like those should be given full faith and credit, I don't think you need to go to an attorney and be like, is my adoption decree still good here? But I would say like, say that you did a donor agreement with me and you had a child and then you moved to another state and we're having a child there, like a second child, I would say yes, consult with an attorney because the laws are different. Like for example, in New Jersey, they really want a doctor to be involved. Like it's not really worth having a contract maybe there's some value, but I don't feel comfortable drafting donor agreements for at-home insemination in New Jersey because I'm not confident that they would hold up. And so there are nuances like that you should always speak to an attorney where you are at the time that things are happening.
Okay, so I understand that for like, I've moved and now I'm having a second child, I wanna make sure that that new child has all the right paperwork. Is there any risk to the legal rights to my first child who moved with me to the new
Where
state?
you have like
now that we've moved?
where you're like, and you have an adoption decree?
I guess any of it, like
So that's sort of the reason, like, why you want an adoption decree, like, because,
Sure.
like, I feel confident those agreements, like, no donor agreement, say it's a no donor agreement, would
Okay.
hold up in Pennsylvania, but, like, do I really, like, and I think they should, like, it always has a choice of law clause and says, like, apply Pennsylvania law,
right.
but the reason why, like, I would feel much more comfortable, like, with people having an adoption decree that says, like, you must recognize this, it's entitled to full faith and credit, rather than another court in another state, like, interpreting my agreement under Pennsylvania law, and, like, say it was at-home insemination, and it's a state where, like, they don't like that. I hope that they would enforce the agreement. I think they should enforce the agreement, but that's why we want to do the confirmatory adoption, to make sure that there's no question about rights. And for gestational carrier, that's driven by where the carrier lives. So there are some circumstances where you can get a pre-birth order in the state where the intended parents live, but usually, like, the law people sort of look to first is where the carrier lives. And so, like, sometimes there are reasons why you might not draft it under that state law, but most of the time that's going to be, you look to that law first and then you can sort of go from there. and they're like, usually it's helpful to have there should always be an attorney in the state where the gestational carrier lives saying what's going to happen, because I have been able to use like a Pennsylvania order in a state like Arizona without a problem, but that's not going to be true in every state.
Cool. And I forgot that most contracts would say like we're using Pennsylvania law
Yeah.
if we ever have a problem with this contract, so that fixes that for me. And then like I guess if we were to move outside of the US, that's just like a huge variable of what all those other countries will think of us, and there's maybe not much we can do about it ahead of time.
I think having adoption is better than not,
Sure.
because like there should be recognition of that, like
Standard.
under Hague and stuff, but it has to be a Hague country, like, and then like donor agreements and all that. I think I can't even say. I feel like I need to like
I'm
speak to
asking the
another.
question, but I know it's the broadest question
Yeah.
possible to answer. So okay, great. I appreciate it.
But like to that point too, like is there anything you need to be worried about with traveling to other countries? Not even just like living,
Not
but
living
just
there.
traveling with your family.
Well, I think having like all the stuff that you can have is always better than not having all the stuff that you can have. But I don't know. I mean, I'm sure in certain countries that there's probably a higher level of discrimination than there is even in certain places in the U.S. where we think that there's discrimination. And so I don't know that I can like really accurately speak to that other than to say like there's a lot of variability. I know with surrogacy there's a huge amount of variability. Like that's why people come to the United States for surrogacy is because in some other countries, it's not legal.
Got it.
Anything else?
Great. We're
Oh,
just about out
great.
of time,
This
so
was
that
really
all
nice.
works out.
That was a lot. I didn't know I could talk for that.
Yeah, you went on for over an hour.